Hello friends, hope you are fine and doing well. I once again welcome you with yet another topic which is very interesting and not very complex, I would say, but very important from the investigation point of view or from the point of view of establishing the guilt of the accused. See, CRPC NVC's provisions to secure the interest of the state, to maintain the public peace and order, and to ensure the individual liberties. Individual liberty has always been considered on the highest pedestal for the reason that it is so sacrosanct, even have been recognized by the Constitution of India under Article 21 as a fundamental right. Now, as we studied the topic of arrest, that somebody's liberty should not be confined without the due process of law or without the authority of the law. Clearly, the search should not be conducted randomly unless it is so warranted and there are sufficient grounds or the reason with the authority concerned to do so. The provisions have been envisaged under section 91 to 100. These are the general provisions. 101, 102 also describe certain things about the search as to how it is to be conducted. Even section 103 says that in the presence of the magistrate the search could be conducted. So 91 to 103 deals with the general provision of the search. Section 165 and 166, as we read in chapter 12 of the investigation, it talks about the carrying out the search during the investigation process. Now, when the case is registered, FIR is registered, police is investigating the matter, without warrant, there are certain provisions, that is section 166, carry out the search, provided they feel sufficient, the possible evidence is there. Without warrant. Now, since I said that it's a most important function, I will just illustrate here. For example, a crime takes place. Say the B has stabbed A is lying on the floor, blood is oozing out, lot of people gathered, C is the one who has actually seen the occurrence taking place. Police come on the spot and start taking the statements under section 161 from the passers-by or the persons who have actually seen the occurrence. C states that he has seen B stabbing A with a knife. Now, B is ultimately arrested. During investigation, he suffers a statement which is called disclosure statement with regard to recovery of the knife. Because in section 27 of the Indian Evidence Act, we will study that only the part of recovery which led to the recovery of an weapon or any article which has a nexus with the crime is admissible in evidence. Otherwise, section 25, 26 statement before the police, as you all know, is not admissible, but only up to the recovery part it is admissible. Now, B has got the recovery done to the police of a knife with the help of which the crime has taken place. Now, this knife is required to be produced before the court for the inspection and to establish the guilt, because the statement of the C will not be sufficient enough to establish the guilt. There has to be some substantive corroborative evidence. What is substantive evidence? Why it is required corroboration? We would be discussing this concept in the forthcoming lectures. But here, since we have been talking about search, I just want to explain you as to what is the importance of the search. Since police has reached at the spot of occurrence, collected the knife, blood-stained cloth, even blood samples, from the they collected, and all the samples and the knife is sent for the chemical examination. Now all this evidence is available before the court now. The court solely cannot base the conviction of an accused on the statement of the C, the corroborated with other material evidence. Now the chemical examination report would be taken into consideration if it says that blood on the knife, it actually matches with the blood of the victim or the deceased, or it has a fingerprints of on the knife, or even the blood-stained cloth of the deceased or the victim matches with the blood sample which was sent for the chemical examination. Now this material is sufficient enough to corroborate the evidence and to base the conviction of the accused. Therefore, search and seizure plays a very important role. It has always been, as far as possible, been done by the experts, people who are having a specialized knowledge and who are well versed with the norms and procedures also. Because in case the procedure laid down under CRPC is not followed, then it would really hamper the case of the prosecution. It may be proved to be fatal. So such a eventuality should not emerge or arise. The Honorable Supreme Court in the various judicial pronouncements have said there are specialized agency who is to carry out the investigation, who is to conduct the investigation, should be engaged, especially for the heinous crimes or the crime which are white collar crime, or wherein suppose the forged documents were being used, or cyber crime, or the cases pertaining to terrorism, drugs, and the all heinous crime, murder, rape, these kind of things, wherein Supreme Court has said that a specialized agency should be engaged, and so that the evidence could be collected in a just and fair manner, and it should, when it is put to the judicial scrutiny in the court of law, then guilt could be established. Now Supreme Court has come if the evidence was available, a crime is taking place in an open market, there was a CCTV camera footage. If the footage has not been recovered from that particular place which was in the knowledge of the investigation officer, then investigation officers would be held liable for that, and very serious consequences would be emerged against him in case the material evidence which was available were not taken into consideration. So my dear friends, my only concern was to say that it is a very, very pious, special, and the moral or the legal obligation of any officer, because ultimately on the basis of the collection of the evidence, the guilt is to be established, because court is not coming physically. Whatever is produced before the court has to weigh that evidence, and accordingly the conviction is to be given or the guilt is to be established. So it has to be by the trained experts, experienced, and the people who are having a specialized knowledge to this effect should be engaged for this purposes. Now Section 3 of the Indian Evidence Act says that it includes all the instrument by which relevant fact can be brought before the court. So whether it is a document, article, weapon, anything that could be brought before the court for the inspection and for establishing the guilt. Now Section 2H defines the investigation, which says that it includes everything under the code for the collection of the evidence. Now court can issue summon under Section 91. Now what is summon? The See, I would be recording a different lecture on summon and warrant in detail, but herein what you need to understand the meaning of the summon. It's a command of the court to an individual to produce document or anything. So if something is very vital to prove the fact in issue or the relevant fact or the matter before the court, then the court may summon the concerned person to come and produce that document or that thing. It's a command by the court. Section 91 defines the summon could be issued not only for the appearance of the person, but also the command could be given to produce the relevant thing also. Section says that if anything is in possession of the postal or telegraph authority and which is required to determine the case, to adjudicate the matter before the court, then it could be issued to the authorities concerned. Now section 93 is very important. It's a warrant. Now I said that under section 165 and 166 of CRPC, when the police during the investigation is not required to obtain a warrant, wherein the general provision says that warrant is required because the individual liberties are sacrosanct in nature, should not be curtailed without the due process of law. Therefore, it is mandatory for the police to obtain a warrant. Now, both executive and judicial magistrate are empowered to issue the search warrant. Now, under what circumstances this warrant should be issued? Now, we will read it further. Under what circumstances warrant should be issued? Now, section 93 says that warrant could be given to the police authorities to conduct search or seize some article, object, vehicle, premises, area, whatever. For these reasons, for these things, this could be given. Now, why it is required to be given? Section 93 speaks about two things. One, that a person who is in possession of these things, an article, and not coming before the law, despite of the summon, that then to ensure its presence or its availability in the court, the warrant could be issued. One. Second, if it is not known to the court as to with whom it lies or in whose possession it is, then in order to conduct a search, this warrant could be issued again. Fine. Section 94 says that if the police has a reasonable belief, or the court also is aware of the fact from the police itself, that certain stolen property has been deposited somewhere and this is also being sold. Now, in order to conduct search at that particular premises or area or location, the search warrant could be issued under section 94. Now, section 95 says that if some newspaper agency or some publication house is publicizing the news which ultimately attracts the offences such as 124 sedition, 153A and B waging war against the government, 292, 293 and 295A. 292, 93 deals with the obscenity, and 295A, I mean, if you have been spreading some news which creates the hatred and the feeling of disharmony, I mean, the religious sentiments you are going to hurt. If this kind of things are being done by any publication by way of a book or document or newspaper or a magazine, then the warrant could be issued to conduct search and seize the publication house. Now, those who are into a regular practice would tell me, those who have been viewing it will tell me what is the remedy before the publication house, or passing a comment in the comment box. What is the remedy before the publication house if in case it is forfeited by the police on account of the facts we have just discussed? Fine. Section 97 further says that if somebody has been confined into illegal custody, then the search warrant could be issued. The corresponding provisions in this regard we read in Constitution. The writ of habeas corpus we usually file before the High Court fine, wherein the directions are given, and even the warrant officer is appointed to conduct the raid where the illegal confinement has taken place, but the concerned magistrate or the executive magistrate even, they are not helpless. If they have a strong reasons and belief that somebody has been confined and an application comes to them, the order could be issued to conduct search and get the person released from the clutches of that fellow who has kept the person under the illegal confinement. Now, Section 98 says that if a female below the 18 years has been abducted and confined, then the search warrant could be issued to get her released also. So, when search warrant could be issued, under what circumstances, I have just explained it to you. Now, Section 100 is very important, which deals with the general provision. Now, how the search is to be conducted and what considerations are to be kept in mind by the police so that he could prove the recovery in the court of law, fairly, and the case of the prosecution doesn't turn out to be fatal when it comes to the judicial inquiry. Now, first and foremost thing is, because as I said earlier, that it should be done in a very specialized manner, keeping in view the parameters laid down under the code. Fine. The person concerned has to join two independent witnesses while conducting the recovery, while conducting the search or seizing the things from the premises or from the spot of occurrence. Now, two independent witnesses has to be there, and they should be the inhabitant of the same locality. In case they are not available from the same vicinity or the same locality, then the reasons are to be given and the two persons could be joined from some other locality also. The occupant of the premises should be present. In case he is present there, then he should be joined. Signature of the independent witnesses, the concerned and the occupant should be taken on the research memo also. Why so? Because when later on the question comes to the recovery in the court of law, these witnesses could be called there and the genuineness of the recovery could be established in the court of law. If a female is to be searched personally, then it should be by the female officer in due regard to her dignity should take place. Then the person, almost everything I think I have covered. Yes, if a person refuses to join, if person, despite of the request of the concerned police officer, refuses to join, then the provision of section 187 IPC could be attracted against him. He could be booked for an offence under section 187, because it is a moral obligation of every citizen to help or to provide aid to the police agency so that they could work effectively and smoothly, and because ultimately they have been discharging their functions or performing their duties to safeguard the interest of the public only and to maintain the law and order. So it turns out to be our obligation to aid as far as possible should be. Proceedings, vitiate the trial, fine. Lecture we would be discussing this aspect where the proceedings of trial proceedings are to be vitiated under section 460 and 461 CRPC. We will read as to how fatal the procedure or the would be in case the compliance is not made. One last thing, see, since I said that it's a moral obligation of us, once the person is having a search warrant, he comes to raid the premises to conduct the search, he should be given free ingress to that. If the ingress is not given, the passage or the path or the ingress is not given to him, despite of the fact that he shows you a search warrant, then he can use the reasonable force as provided under section 47 subsection 2 of CRPC. Now, this force should not be used unreasonably or in an unjustified manner But yes, the section provides in order to collect the evidence, if where it is required, then the necessary reasonable force, I mean the window or the door could be broken by the concerned authorities, and in case of resistance or in case of not providing the free ingress to the things. So this is all, my dear friends. We have discussed the concept of search and seizure. It is one of the most important function after the arrest of the accused during investigations or otherwise, because police has to perform two functions mainly: to prevent the crime, or in case the crime takes place, then is to investigate in a just and fair manner. So while preventing the crime, if they get some substantive information from some source that some illegality is going on, then they are not helpless. They can obtain the warrant from the concerned magistrate, whether it is a executive or the judicial, and they can raid the premises, can conduct the search and take things in their control and custody or in possession. So thank you very much. See you.